Welcome to TIL Legal Tips. We discussed in our previous video about the scope and purpose of RERA, its registration and importance. Today we are here to talk about another important aspect, which is where there is a right, there is a remedy. We will be discussing the remedies available to a home buyer in case of default by a promoter. To help us with this topic, we have our expert Sushila Ram Varma, advocate and chief consultant at the Indian Lawyer and Allied Services. Thank you, ma'am, for being with us for these legal queries.
Sure, Sakshi, let's go ahead.
First of all, ma'am, I wanted to ask you whether the builder can delay in handing over the unit under RERA.
The answer is a very emphatic no. The builder is bound to give the particular unit or flat as per the timelines agreed between the buyer and the builder. Generally, the timelines are laid down in the builder-buyer agreement, and the builder has to provide the unit as per those timelines. Another very important thing is if the builder delays the project under the RERA Act, the buyer has the option of demanding that the advance be paid back to him along with interest. Additionally, if there is a delay and the buyer condones the delay, that is, agrees to take the apartment or flat with delay, then the buyer can demand compensation and the builder will have to pay that compensation.
Well explained, ma'am. As you already told us, the object and reasons of the Act provides that the real estate sector is largely unregulated with an absence of professionalism. So what are the remedies available to buyers if builder fails to give the possession?
Sakshi, today the buyer has two remedies. Before the RERA Act 2016 was passed, all these builder-buyer disputes used to go before the consumer court because a buyer was deemed to be a consumer within the meaning and definition of consumer under the Consumer Protection Act. Now what has happened is the buyer can go as a consumer to the consumer courts for his remedy, or he can go as a buyer under the RERA Act, that is to the RERA authority or the adjudicating officer, who is also a part of the RERA authority. Now, what happens is the decision is up to the buyer. The buyer can take a call as to whether he wants to go with an act and claim deficiency in services under the consumer law and demand compensation and refund and possession, or whether he wants to go under the RERA Act, which is a specific act for real estate issues, and take up his claims. In both cases, the buyer will have nearly the same timelines because both these courts have a summary procedure and can act fast.
Thank you. Moving towards to our next question, what does a RERA court generally do when a buyer approaches it?
Well, the first step would be that the RERA court would examine the complaint and see whether there is a prima facie case. If the court feels that there is a prima facie case and that the complainant's case should be heard, it will issue notice to the builder. Once the builder appears before the court will hear the builder briefly and then allow him to file a reply. Once the reply is filed, the court hears the case on merits, that is, hears the complainant side of the story and the builder's side of the story, and then decides the case. Now, once a matter is decided, then you get a decree. Now, whichever side wins the case can execute the decree as by going to the execution court. Now, what generally happens is, after the decree is passed, the side that loses the case, that is the judgment debtor, goes in appeal. Now, this process of appeal can be very lengthy and time consuming. So, what happens is that the RERA law has got a special mechanism for, or a safety mechanism for the buyer. The RERA court insists that anyone going in appeal, and in most cases it's the builder, they have to deposit a mandatory pre-deposit with the court, which is kept with the court till the matter is finally disposed of. And when I say finally disposed of, I mean till the matter reaches the Supreme Court, if at all the parties decide to go there.
As you are discussing about the court, is there any other forum where a buyer can approach?
Yes, the buyer can approach the consumer court also, and apart from the RERA courts. So the buyer has two options.
You mean to say that buyer have also a remedy under the Consumer Protection Act?
Yes, certainly, certainly.
Okay, ma'am. Thank you. Coming to the RERA, under the RERA, one is regulatory authority and other one is adjudicating officer. Being a layman, how does the buyers know who he has to approach?
Good question, Sakshi. This would depend on what is the remedy you're seeking. If you're seeking possession, if you're seeking delayed payment charges, if you're seeking refund of the amount that is due to you, then in such cases, you will approach the RERA authority. If it is only compensation and interest that you're seeking, then in such a case, you will go to the adjudicating officer. But invariably, what happens is that all matters come to the authority because there are more issues than just calculation of interest. Then, in such a case, the authority decides the case and then sends the case to the adjudicating officer for calculating the interest and the compensation that the winning party should be awarded.
Are there any judgment which you wanted to share with our viewers pertaining to real estate matters?
Yes, there is a recent 2022 judgment. It is called Experion Developers versus Sushma Ashok Shiru. In this particular case, the court has held that a buyer has the remedy under both the Consumer Protection Act as well as the RERA laws. So the buyer can file a case in either of the two forums, or it can file in both the forums, depending on what is the relief that the buyer is seeking. For instance, in the consumer court, you can approach the court for deficiency in services. That is when the builder fails to give you proper services. Whereas in the other court, in RERA court, you may not have that option. You can only seek a refund or compensation or possession, etc. So in such a case, you can go to both courts, but of course, it is not really advised because litigation in India is very, very long and time consuming. One more case which I wanted to mention. Generally, home buyers are deemed to be financial creditors under the Insolvency and Bankruptcy Code. A matter came up before the Supreme Court very recently in 2023, in which the builder side argued that a home buyer who had got a decree cannot fall in the category of financial creditor, but should actually be put in a subcategory. The Supreme Court held no. All buyers will fall in the same class as financial creditors. They will have the same rights as buyers who have not got a decree of court, and all of them can approach the NCLT, that is the National Law Company Tribunal, under the Insolvency and Bankruptcy Code as a financial creditor. So I think with this, we can wrap up this session. A small piece of advice to all viewers. I know that you put in a lot of your hard-earned money to buy apartments or units from builders, from big builders, and invariably your money gets stuck. in your anger and in your haste, you want to go and sue them. But believe me, I, as a lawyer who has been in the system for so many years, I would advise that as litigation in India is very protracted, it is better if there is a dispute resolution mechanism or an alternate way of settling a dispute, take up that option, exercise it, take your money and go back home satisfied. Take up litigation only as a last resort because it's very time consuming and very frustrating at times in our country. Thank you. And with this, I would like to say that if you have found this video useful, please like, share, and subscribe so that we can make many more such videos which will educate the common man. Thank you and have a good day.